But welcome everyone. Good morning. Welcome to our 2025 Mid-Year Labor Law Update webinar. Today is sponsored by our partners over at the Central Valley Regional HR Hotline, who you will hear from in just a moment. My name is Anna. I'm the digital media and event strategist here at the California Employers Association. Again, we just want to thank you, for taking time out of your Tuesday to train live with us. Before we get into today's training, just a couple details to go over with you if this is your first time with us. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities and invitations to engage during today's training. So we hope that you keep this up for us today. If you do have any questions about the content, the best place to enter those questions is going to be in the Q&A box. So while one trainer is delivering the content, we'll have another one managing that Q&A. I will be here the whole time supporting them, watching the chat. If we do have a pretty fast-moving chat, I might just ask you to copy your question into that Q&A box, just so we make sure that that gets addressed in a timely manner. So I might just ask you to copy it over there. Handouts for this training will be dropped into the chat box shortly. So once you see that PDF icon and file name pop up in the chat, you can just go ahead and click it and it should download locally to your drive. Again, I'll be here the whole time watching. So if you have any issues accessing that PDF, please just let me know in the chat and I'm more than happy to troubleshoot that with you. As you saw when you logged on, this webinar is being recorded and the team over at Central Valley will be reaching out when it's available for review. And then last but not least, we do have a very brief survey at the end. So I will be inviting you to share your feedback. You'll see a slide with a QR code. I'll also drop a hyperlink into the chat for your convenience. But the whole purpose of the survey is to make sure that we are meeting and hopefully exceeding your expectations with trainings like this, as well as our entire suite of resources available to employers like yourself. So if you can take a minute at the end, it's only 5 questions. And this is also the place where you suggest training topics that you'd like to see in the future. So we encourage you to take the minute at the end. So again, our training today is brought to you by our partners over at the Central Valley Regional HR Hotline. Today, we're joined by our partner, Valerie Chavez, who is a staff services technician who is going to be available. Valerie, did you want to say a few words or did you want to just drop your information in the chat for us?
Yeah, I'll go ahead and drop my info in the chat. Thank you.
Perfect. Perfect. Well, thank you, Valerie, and your entire team and this entire co-op of Central Valley workforce boards and resources for employers like you all. So we really encourage you to take note of this slide, as well as this slide will be included in the PDF that I'll put in the chat shortly, because then you can figure out what county you are in and then call the appropriate HR hotline. And our trainer will speak to that in just a moment. So with that note, I'd like to introduce our trainers today. We have Juliana Gabriel, our Senior HR Compliance Director, who will be presenting today. And then we have Mary Bradford, our Senior HR Director, who will be managing that Q&A. So you are in great hands, and I'm going to hand it over to Juliana.
Thank you, Anna, and good morning to our Central Valley employers. We're very excited to have you join us today. As Anna mentioned, we do have this no-cost HR hotline that is sponsored by the Central Valley counties that you see here. And we can help you out with questions, whether it's hiring and firing paperwork, maybe you have a wage and hour question, leave of absence issue. You can call into this hotline number that you have for your county and get the guidance from a live HR advisor. So if you do have an outstanding question after today, maybe you think about it after this training, please take advantage of that and call in. But Mary is in that Q&A box and she is ready to answer your questions about the content today. For those of you joining us for the first time, I'd like to introduce California Employers Association, or CEA. We are an HR consulting company. We have members located throughout the state of California and beyond, and our goal is to provide you peace of mind with exceptional HR compliance solutions. So if you find you do need some additional HR support beyond the hotline, you can join us as a CEA member. That would give you access to our hundreds of HR forms, sample policies, toolkits, which our team is constantly keeping up to date with all of California's changing laws. And we can also help you out with your HR to-do list. So if you need a customized employee handbook, some harassment prevention training for your staff, assistance with an internal workplace investigation, we can help you out with all of those types of HR services. So we have our website listed there at employers.org. You're also more than welcome to just call into us directly with any questions that you have about that. I do want to remind you, though, that CEA is not a law firm and we cannot give you legal advice either when you're calling in on the hotline or on these trainings. We are always just giving you best practices and general guidance. So if you do have an issue of legal significance, make sure you consult your own attorney about that. But as we mentioned, we're happy to answer questions about the content today. So please direct those to the Q&A box. And then any sort of technical issues or needing the handouts, you can go ahead and direct that to the chat. All right, so let's talk about what is on our agenda today. We've had a very busy mid-year season, and a lot of it has been coming from the federal level. So there's been a lot of executive orders, obviously, with employer impacts, especially related to diversity, equity, and inclusion programs, increased immigration enforcement. And you might be wondering, well, how does this impact me as an employer? Or as a California employer, what steps should I be taking? So we're going to cover that today. And then on a state level, we have some wage and hour updates, some increasing local minimum wages that just happened recently on July 1st. We also have some new case law and interesting regulations. So one of those is on artificial intelligence. We will talk about that. And then we'll close out with some summer reminders for employers on things like your workplace violence prevention plans. Remember, we have annual requirements there. Key illness prevention. We'll talk about all of that. All right, so let's start with navigating a new administration. This is the theme of our mid-year labor law update. And our focus is really just on compliance. So we know that there could be a lot of different perspectives on the federal initiatives, but what do you need to know as an employer? Well, with increased immigration enforcement, it's really important that you're paying attention to your Form I-9 process, that you're conducting regular audits. We'll go over some best practices there. If you do receive a notice of inspection for your I-9 records from an agency like ICE, there are some unique California requirements with how you have to respond. So we'll talk about that. And then we'll get into those executive orders on diversity, equity, and inclusion and what that might mean for employers. All right, so starting with just a refresher on Form I-9, as a reminder, federal law since about 1986 has required all employers to verify both the identity and employment eligibility of all newly hired employees. And the way that we do this is we complete that federal document, that Form I-9. And we do not need to file this with any sort of agency like USCIS, but we do need to retain those records in case we get an audit request or a notice of inspection. And what our general duty is as the employer is to verify that it appears that the identity reasonably relates to that individual. So their name or perhaps their photograph seems to match, and that the documents appear authentic or genuine, that it doesn't seem like we're receiving some weird photocopy or fabricated document. So we're not expected to be document experts, but we do have to at least ensure that the documents satisfy that threshold. Now, of course, there's penalties for failure to comply with this process, and they really range. So some are just document errors where maybe we missed a part on the I-9 form or we entered slightly incorrect information or a name. But some more serious are if we are potentially knowingly employing someone who is not authorized to work, and that can become very steep penalties if we do that. So really important that you're paying attention to your Form I-9 process. There's a really great handbook out there for employers developed by the USCIS. It's known as the M247, and it answers a lot of frequently asked questions regarding this Form I-9. So I want to start with a little pop quiz here. You can get out the chat box. Our new employee started work for us on Monday. When is the deadline to complete their Form I-9? Is it A, Monday on or before their first day of hire, B, Thursday within 3 business days, or C, within 7 calendar days of hire? Let me know what you think here, and then we'll talk about that. All right, I'm getting a lot of answers coming in, and you guys are right on top of it. So B, under most circumstances, the rule would be within 3 business days to complete the Form I-9. Now, remember, Section 1 is the employee section where they complete their information details about themselves, their name, address. That has to be completed by the first day of hire. So that's something that you want to make sure you check off on the very first day. But the employer section, Section 2, where you review their employment documents, that can be completed by the 3rd business day of hire. So with new candidates, we really recommend that you let them know that they need to bring in their I-9 documents on the first day of hire, just in case there's an issue or they don't bring in the correct combination of documents. And prior to them coming in, provide them the I-9 instructions and list of acceptable documents that come with the I-9. They get to choose which document or combination of documents they bring in. So that's the best way to handle it. Now, if you're hiring someone for a very temporary period, less than 3 days, then you need to complete the entire I-9 form on or before their first day of hire. All right, so what are some updates when it comes to the I-9 form? It was recently updated. There is a new form edition as of 1/20/2025 that you might see out there. And that was really aimed at just changing some of the language on the I-9 form to align with the ideology and policies of the current presidential administration. So some changes that you might see, instead of a non-citizen authorized to work, it's now labeled an alien authorized to work. They replaced the word gender with the word sex. So not a ton of substantive changes. The last time that we saw a really big overhaul of the I-9 form was back in August of 2023. And that's when it was reduced to a single-sided sheet. So they tried to make it a little more user-friendly, where you have sections 1 and 2 all on the same side. They also made it fillable to be used on tablets and mobile devices. So sometimes people wonder, well, can we complete the I-9 process? Can we fill it out, that form, electronically? And you are allowed to fill it out and retain it electronically as long as you satisfy certain steps to make sure that you're maintaining that in a secure way. Some other changes that you might see. So they've moved the Section 1 Preparer Translator certification now to a separate standalone Supplement A. You only need to fill this out and attach it to the I-9 form when someone has either helped the employee fill out that Section 1 or translate the I-9 form for them. And then it used to be Section 3, Re-verification and Rehire, has now been moved to a standalone Supplement B. And again, you only need to use this when you are either re-verifying employment. There's only certain work authorization documents that when they expire, they have to be re-verified. Certain ones you never have to worry about, so you don't have to worry about it for US citizens, or when List B documents like a driver's license, for example, expires, or passports, permanent resident cards. But there's some work authorization documents for aliens that when they do expire, you have to re-verify. And so that's what Supplement B is used for. Also, if you're rehiring someone within 3 years from when they originally completed their Form I-9 form, you don't have to redo the whole Form I-9. You could just use that Supplement B and attach it to the original form. But if it's been more than 3 years, you do have to start over with a new I-9. All right, so the question we've been getting, should I correct or replace I-9s of my current employees because there's this new form now? And luckily the answer is no. So as long as the version you used was not expired when you completed the I-9, you don't have any sort of requirement that's triggered where you need to go back and update I-9 forms or re-verify information. So it's only that situation that I talked about when re-verification is required. Otherwise, you should not be engaging in a new I-9 form just because there's a different form version. All right, now when it comes to auditing your I-9 form, we have long recommended that you're doing this on at least an annual basis, but especially now with increased immigration enforcement, it's a really good idea. And the reason is if you audit your I-9 forms, you have the opportunity to correct the errors that you find. So you can correct them right there on the form. And then later, if you do get a notice of inspection from an agency like ICE, you might avoid penalties that way because you've already corrected the error. And it just generally also shows good faith that you have this audit process. They typically have ranges that they can choose from, the minimum to the maximum on certain penalties. And so that good faith effort could potentially weigh in your favor. So what we generally recommend as you're auditing your I-9 form is first audit those I-9s that you're no longer required to retain. So generally, if it's been at least 3 years from someone's hire date or 1 year from their termination date, whichever comes later, you can then discard the I-9 forms. So that means for current employees, you should always have I-9 forms on file for them. But for former employees, once you've met those retention requirements, you can discard those ones that you no longer need. The next step would be to go through the ones that you do have to retain on file and then check them for any errors or missing information. Generally, what you can do is just draw a nice clean line through the incorrect information, and then you're going to enter the correct information either to the side of it or above it, and then you're going to always want to initial and date the correction. What we never want to do is conceal any type of corrections or try to backdate something. Let's say we didn't meet that third business day on the I-9 form. We don't want to backdate and pretend that we met that third business day. We also don't want to use whiteout. So you need to see what the error was, what the correction is. For any Section 1 issues, that has to be completed by the employee or their translator. Section 2 issues, the corrections can be made by the employer. And then it's a really good idea to prepare a written explanation of just what the error was, your good faith efforts, and then sign, date, and attach that to the I-9 form to keep it with the records in case you do get a notice of inspection. And CEA can assist employers with their I-9 audits. You can reach out to us if this is something that you're interested in doing and you need some help out with. All right, so now I want to talk to you about some of California's unique requirements when it comes to a notice of inspection that you might receive from a federal agency like ICE, for example. And that is typically when they want to review your I-9 documents and related records. Now, when you do receive a notice of inspection, you typically have to have those requested records or produce them within 72 hours. So we recommend that you keep your I-9 records very organized. Typically, we would say have a binder separate from the personnel files, alphabetized with all current employees, and then one for all former employees. And then you can also track record retention a little easier that way. If you're a larger employer, you don't want a situation where you are retaining I-9 forms in a bunch of places or a bunch of different personnel files, because if you get that notice of inspection, it doesn't give you a lot of time to pull all of that together. Now, once you do receive a notice of inspection, California has this unique requirement where you basically have to give your employees a heads up of that. So you have to post the notice of inspection for employees within 72 hours. Our California Labor Commissioner has a sample template for the notice that you can use to post that up in your workplace to give them a heads up. And then if the agency does identify any particular employee as potentially lacking work authorization or not having proper documentation, you actually have to notify that employee directly, give them basically a copy of those government findings within 72 hours of receiving that from the government. And they want you to give this directly to the employee unless they are not available, they've left your workplace for some reason, then you could mail or email that notice to the employee. Now, notice of inspection is different from what's known as an ICE raid, and that is typically when ICE is showing up unannounced to the workplace, typically to search the workplace, possibly to arrest someone or gather evidence. So again, it usually comes by surprise. Now, some tips in this area. Employers are allowed to refuse to allow ICE to enter any non-public areas unless they have a valid judicial warrant to enter that area. So, for example, ICE can freely enter, even without a warrant, places like parking lots or dining areas where you allow your customers in, or waiting rooms, those kinds of places where customers are allowed to freely access, but employee only or authorized access only areas, they would not be able to unless they have your consent or a valid warrant to do that. So one tip is to actually mark those private areas with signage that can help to tend to show that that's a private, authorized access only area. Another thing to know is that workers do have a right to remain silent. So you can let workers know that. Some businesses have more concern with ICE raids happening, and so they have conducted ICE drills where they actually practice, okay, what's our response? What do we do in this type of situation? Another tip for employees is to not take off running when ICE shows up. That can provide a basis to arrest. CEA does have additional resources if this is an area where you would like more information. We have some blog articles that we've written on this with additional resources to other organizations. So you can access that at employers.org, and I'm sure Anna will put that in the chat for you as well. All right, so wrapping up our Form I-9 to-dos, what do we want to pay attention to? Make sure you have a compliant process in the first place for completing those Form I-9s at the time of hire in a timely fashion. And then get into an annual audit cycle where you're auditing your I-9 forms, correcting any deficiencies, at least on an annual basis, is what we would recommend. And then if you do receive that notice of inspection, remember that California has those unique requirements and that our labor commissioner has a sample notice that you can post to give employees a heads up of that. If you are a CEA member, you do have access to our I-9 self-audit toolkit to help you through your own audit, or again, you can contact CEA for assistance in this area. All right, so now I want to shift gears a little bit and focus on a couple of the federal executive orders as they pertain to diversity, equity, and inclusion programs. But I want to start with just a little bit of history or context with kind of where we stand today with DE&I programs. So it's actually been quite a while since diversity became a topic in corporate America, one that was focused on in corporate America, starting in around the 1980s and 1990s. We started to see these diversity programs first appear with really a focus on increasing global competition. That was kind of the idea behind it, that a more diverse workforce is going to be a more successful one. And then over the years, it's kind of waxed and waned in attention. You might have noticed that back in 2020, there was a lot of increased attention with DE&I after the George Floyd and Breonna Taylor incidents. A lot of companies started really developing robust DE&I programs, or maybe even hired for DE&I specific roles like a DE&I officer to oversee those efforts at the organization. And then 2025 hit, and we've started to see this cultural shift with a lot of large companies pulling back from their DE&I programs and initiatives. So some examples of that are Walmart, Target, Amazon. And you might be wondering, well, what's going on here? Why the sudden shift? And arguably that's due to the new presidential administration and their agenda and executive orders. So I want to talk about some of those executive orders now. And the first one is EO 14173, and this is known as Ending Illegal Discrimination and Restoring Merit-Based Opportunity. It's also known as the Illegal DE&I Executive Order. So what this does, one of the things it does is it takes the position that certain DE&I programs create discriminatory preferences for minority groups that violate federal civil rights laws. So basically, the federal government is indicating we are going to take another look at some of these employers that are potentially having these discriminatory preferences for minorities. Another thing it does, and this has created a lot of questions for federal contractors, is it revokes federal contractor and subcontractor affirmative action requirements. There's some exceptions to that. So with veterans, for example, is one exception to that. But for other minority groups, it revokes affirmative action requirements requiring these federal contractors to develop affirmative action plans, audit that they are providing opportunities for underrepresented groups. And instead, it kind of flips that. Now these federal contractors have to certify that they are not engaging in what is known as this illegal DE&I and audit their practices, roll back maybe some of those DE&I programs. Another big key point is it requires the Attorney General to provide recommendations for combating illegal DE&I and identifying potential high-profile compliance investigations. So basically targeting large companies, publicly traded companies, or nonprofits that are operating with a DE&I program that's discriminatory. So you can kind of see now why you've seen a lot of these large organizations pull back and away from these programs. The EEOC does have updated guidance on what would be considered DE&I related discrimination. We have this bit.ly link here. You can put that into your browser if you're interested in reviewing that. So kind of the million-dollar question for employers or California employers is, does this executive order make a DE&I program illegal? And not exactly. So first, the executive order does not change our discrimination laws. So employment decisions that are based on a protected class, whether they're part of a DE&I program or not, have always been illegal. So it's a common misconception that only minority groups are protected. Everyone is protected, that employment decisions are based on job-related reasons and not based on something like someone's race, gender, religion, whether it's used against them because they're in a minority or not. As a practical matter, though, employers with D&I programs are probably going to come under increased scrutiny and enforcement, and particularly these larger corporations. So it is something we want to take another look at, because with a new administration, the tide has really shifted on enforcement efforts. So it is not unlawful to maintain a diverse and inclusive workforce, so we can start there. But we do need to ensure that our employment decisions, whether that's who we're hiring, who we're promoting, who we're giving a special assignment or opportunity to, does not give preferential treatment based on a protected class, based on a factor like race, sex, religion, or any other protected class. So some things you want to make sure you definitely are not doing. We don't want to have any sort of quotas based on a protected class. So don't have hiring quotas that we want to hire this percentage of women or this percentage of African American applicants. We want to be careful with that. We also don't want to give any sort of preference points for applicants of certain protected classes or minority groups, that they get a leg up, right, in that hiring decision. Also, for voluntary employee membership groups, they should be open to all. So we shouldn't say this is a women's only group in our workplace. We have to be careful with that. A big pro tip here, what we'd recommend, some proactive steps you can take in this area: make sure you're maintaining updated job descriptions and draft your hiring criteria in advance for your hiring or your promotion decisions, and then train your hiring team on what that criteria is so that they can stand behind those decisions and defend them and say, we hired this candidate because they met this objective criteria and they were the most qualified. It doesn't have to do with something like race or sex. All right, the second executive order that I want to go over with you is 14168, and this one's a mouthful. So this is defending women from ideology extremism and restoring biological truth to the federal government. So what this one states is that the federal government will recognize only two sexes, male and female. It defines sex as an immutable biological classification and rejects the concept of gender identity. Another thing that this executive order does is it rejects the interpretation of Supreme Court rulings that protections based on sexual orientation and gender identity would extend to a requirement to gender identity-based access to single-sex spaces like locker rooms, restrooms. So basically what this is saying, and what EEOC guidance is now saying, is that although the Supreme Court has held that Title VII protects employees and applicants based on sexual orientation and gender identity, we're not going to interpret those cases to go so far as to require this gender identity-based access to places like restrooms, locker rooms, etc. So the Supreme Court hasn't ruled in directly on that issue, and so they're saying we're not going to interpret the Supreme Court cases to be that broad. All right, so again, the question that comes up is this executive order in conflict with California law? Possibly. We'll have to see if the two laws go head to head in some way, but it's important to remember that state law can be more protective than federal law, and that is going to be the case here. So under California's Fair Employment and Housing Act, gender and identity and expression are protected classes. They're required to be covered in mandatory harassment prevention training. And our FEHA regulations require that employees have a right to use a restroom or a locker room that corresponds to their gender identity and be addressed by the name and pronouns of their gender identity or expression. So our guidance from our Civil Rights Department says that if you are repeatedly and intentionally misgendering someone, using, not using their preferred pronouns, that could actually lead to a harassment claim. So we have to be careful here in California. Remember, we are operating under different rules and a different enforcement body. We have the Civil Rights Department. So although the EEOC on a federal level might not pursue something like this based on the new guidance, it's still a risk in California. All right, so let's go over our updates and to-dos in this area. Take a look at your hiring and internal policies. Make sure that you're not giving preferential treatment for certain groups, and take that a step further. If you're using any recruiters, outside external recruiters, I would take a look into their process. I would audit what it is, what factors they're looking at. Make sure that it's not running afoul of these rules. Draft objective job-related criteria for all openings, and then train your hiring managers and recruiters on what that criteria is that you're looking for. Keep those job descriptions up to date for all positions, include the essential job functions. That's important for so many different reasons. It can be hard to get around to getting those job descriptions updated, but it can really be your best defense in a lot of situations. And then continue monitoring federal developments, pending litigation. This is one that changes quickly and often. As of right now, those executive orders are almost fully enforceable, but it could always change in the future. For the latest HR news, you can subscribe to CEA's blog at employers.org. That's where we post updates when there are, and anyone can access that blog. All right, so now that we've gotten through some of the key federal updates, I want to turn to California and starting with our wage and hour updates. So as I mentioned, on July 1st, we had some local minimum wage increases. We also have some industry-specific wages that we have to pay attention to. Something else that's exciting, at least for HR professionals, we have a new case on meal break waivers. So we always love when we get some additional guidance and clarification on wage and hour issues. And then I want to talk to you about California's recommended wage and hour audit based on some legislative reform that happened last year. All right, so let's just start with the minimum wage in California. Where are we sitting at for 2025? So for your non-exempt hourly workers on a state level, they are currently at $16.50 an hour. We want to remember, though, that the state minimum wage is always going to impact our exempt salary amount for our white-collar professionals. So remember, in California, to be exempt, someone would have to pass a duties test. They would have to be engaged in certain duties more than 50% of the time. It's known as the professional, executive, or administrative exemption are the main ones. And additionally, they have to meet this salary minimum. And so that's always 2 times the state's minimum wage. And then you multiply that by 2080 hours a year, and that gives you the annual salary of $68,640. And we cannot prorate this if someone's working, only part-time hours or they don't have as much work that week. The salary has to remain consistent. So if we can't meet that salary or they don't meet the duties test, we need to reclassify them to a non-exempt hourly worker. Anyone in California can be non-exempt, and it means that they have to track their time, take meal and rest breaks, get paid overtime, etc. If you do have to transition someone from exempt to non-exempt, we do have a fact sheet for you on some considerations. You can put this bit.ly link into your browser. All right, now, of course, in California, it's not quite that simple, right? We also have now over 40 different local minimum wages that may apply depending on where you have your workers located. So just a reminder that local minimum wage is based on where the employee is physically performing the work. So you're going to want to check this. If you have any remote or hybrid workers that are working in a different city or locality, check if they're subject to a higher minimum wage requirement. Also, if you're sending them to different work sites or client sites. We also do have some local rules when it comes to things like paid sick leave, for certain industries, predictive scheduling. There was one now for large retail employers in Los Angeles. So we do have to pay attention to those local laws that are kind of a patchwork. They're all a little bit different. Something else to know is that a lot of these local minimum wages go up on January 1 each year, but there's also a good handful that go up on July 1 each year. So just to give you a few examples of those, a lot of them are located around the Bay Area and then also Southern California. So San Francisco went up to 1918, Emeryville's all the way up to 1990, Alameda 1746. And then there's some in Southern California as well. So pay attention to those. We do have this great bit.ly link. Again, you can put that in your browser and access all of the current and current local minimum wages, so you can audit that for your organization and make sure you're paying people properly. All right, so now in California also, another thing that we have to pay attention to is we have industry-specific minimum wages. So a big one was that fast food minimum wage for fast food chains. They're at $20 an hour. We also had healthcare minimum wages that went into effect last year. And they range based on the type of facility. Most healthcare facilities are covered, although not quite all. They initially ranged from $18 to $23 an hour, but there were some increases that happened on July 1. So some examples are some large hospitals, dialysis clinics went up to $24 an hour. A few others went up from 18 to 1863. If you are a healthcare facility, make sure that you check out, there's great frequently asked questions from our DIR. Check out what's the minimum wage that applies to you, when is the next time it goes up. They have a big chart that outlines that based on facility type. And then also there is now a new supplemental minimum wage poster from the DIR with the updated amount. So if you are a healthcare employer, even if your particular minimum wage didn't necessarily go up, make sure you do post that new supplemental minimum wage poster. Now, something to remember when it comes to exempt employees who fall under the healthcare law, to qualify as exempt, they have a slightly different rule when it comes to that salary test. So they have to be paid 1.5 times their applicable healthcare minimum wage or 2 times California's minimum wage, whichever is greater. So every time either California's minimum wage increases or their healthcare minimum wage increases, you're always going to have to do a little math calculation to make sure that your exempt employees are keeping up with that minimum salary amount as well. All right, so I mentioned that we have a new case on meal break waivers. So I first want to start with a little refresher on meal breaks in California, and then we'll talk about the new case. So remember, in California, for our non-exempt hourly workers, anytime they go over 5 hours in a workday, that triggers our obligation to give them a meal break. And that meal break needs to be a minimum of 30 minutes. It's unpaid time, so they're clocking in and out for it. And it has to be completely uninterrupted. So we shouldn't be asking them quick work-related questions or giving them work tasks, right? It needs to be a full 30 minutes of personal time. Now, anytime someone goes over 10 hours in a workday, then that second 30-minute meal break requirement is triggered. Now, there is also, though, an opportunity to waive the meal break under certain circumstances. So for that first meal break, a waiver is allowed with mutual consent of both the employer and the employee if their total workday is no more than 6 hours. So again, the meal break is triggered once they go over 5, but they do have the opportunity to still waive that first meal break if their work is going to be 6 hours or less. If it's more than 6 hours, they cannot waive that first meal break. For the second meal break, if they are working no more than 12 hours and they took their first meal break and they voluntarily agree, they can waive it. Again, it's always going to be the employee's choice whether they are going to waive that meal break. We can't force them to waive the meal break, but a lot of employees do like to waive it because they want to get out earlier, right? They don't want that 30 minutes sandwiched in the middle of their day. So let's now jump into the question that was answered by the California court this year. And I want to hear what you guys think. How do you think the court answered this question? We present all new hires that may work shifts of 6 hours or less with a voluntary meal break waiver to sign at the time of onboarding for all future work shifts that are going to be 6 hours or less. Is this practice okay? I'd love to hear in the chat what you think. How do you think the California court ruled? Did they say, yes, it's okay, or no, this is not okay to get a waiver, one waiver at the time of onboarding? All right, so we have some guesses coming in here. Someone said no, has to be done each pay period. Let's find out what the answer is. So I would also tend to be careful with how a California court might interpret this, right? Because they can be so employee friendly. But surprisingly, this one was a win for employers, believe it or not. So the case was Bradbury versus Vicar Operating. And in that case, that's exactly what the employer did, is they got one waiver at the time of onboarding. They did not get a waiver each time the person waived their meal break. And so they were sued, of course. The plaintiff's attorney tried to argue that this wasn't okay, but the court actually found in this case it was okay. They said employees can make advance written waivers of meal periods for workdays of 6 hours or less. But there were some key facts that they highlighted here. The employer did everything right here. They said that waiver in this case was in writing. It was knowing and voluntary. So the employee knew what they were signing, they knew what they were waiving. It was revocable at any time, so that language was clear in the waiver. And there was no reported retaliation if someone decided one day, you know what, I want to revoke my waiver, I want to start taking my meal breaks. So some best practices in this area. If you do have these written waivers, you can just have one on file at the time of onboarding, but make sure it's a really strong waiver. So make sure the terms of the waiver and the right to revoke are clearly written and explained to employees before they sign. So the supervisor or someone in HR should be explaining what the waiver is, the right to revoke it. If your employee speaks a different language, if they're Spanish speaking, I would make sure that that waiver is in Spanish so there's no argument that they didn't understand it. And then train your supervisors to never pressure employees. So we don't want a supervisor that says, you know, around here, we all waive our meal break. You're going to be the only one not waiving the meal break. Are you sure you want to do that? That would be a no-no, right? The court did not address verbal waivers. We would just not recommend them because you don't have proof if someone verbally waived their meal break. So again, this should be one in writing. If you're a CEA member, we do have a sample meal break waiver that you can use for onboarding or at any time. All right, so next I want to turn to the PAGA reform that happened last year. So for those of you that are not familiar, PAGA stands for the Private Attorneys General Act. And this is a law that basically allows employees to step into the shoes of the California Labor Commissioner and pursue wage and hour claims, not only on behalf of themselves, but on behalf of other employees. And they're similar to class actions in that those penalties can stack really quickly, right? They accrue per employee, per pay period, and it's on top of whatever the employer already owes for the initial violation. So there's been a lot of criticism of PAGA that, you know, there's a lot of well-intentioned employers and they've gotten burned by PAGA. They're very expensive, and a lot of the plaintiffs' attorneys are the ones that are really benefiting from PAGA. So there was some reform that happened last year, or basically employer groups, business groups, and employee and union groups kind of came together and struck this deal, and there was new legislation on PAGA. Now, a lot of it's more relevant to how these claims are litigated, so more for attorneys to pay attention to, but there is something that's really important for all California employers to know, and that is that there are these new opportunities for employers to potentially reduce their penalties by up to 85% if they demonstrate that they're taking reasonable steps to comply with wage and hour laws. And especially we're hearing over the last few years, it's not just large employers that are getting hit with these PAGA lawsuits. It's now more smaller and medium-sized employers. So the legislature did spell out the reasonable steps that they want to see employers are taking. So they said, conduct periodic payroll audits and take action in response to results. So taking a look at things like, are we calculating overtime and the regular rate of pay properly? If we have deficient meal and rest breaks, are we paying required premium pay? Do we have all required information on our wage statements? Those are the type of things you should be looking at and correcting. Distributing lawful written policies in terms of your wage and hour policies. So I would recommend, even on an annual basis, you are having your non-exempt employees acknowledge your policies on timekeeping, meal and rest breaks, and those types of issues. Training supervisors on your wage and hour rules. So they didn't go so far as to mandate required training, but this is a really good incentive now to provide some level of formal wage and hour training for supervisors. And then taking corrective action for supervisors who are not following your policies. So if you do have that supervisor that's pressuring someone not to take their meal break or interrupting them with work-related questions, as an example, you should be following up with them and coaching and disciplining them as appropriate. We do offer a wage and hour audit package to help you with your own self-audit. One of the things it does come with is a 30-minute recorded wage and hour training for supervisors. So if you do need some assistance in that area, that is available on our store page at employers.org. All right, so let's go over our wage and hour to-dos. You're going to want to ensure that your minimum wage rates are adjusted as needed. So make sure to audit, take a look at the local ordinances and keep those salaries up for your exempt employees. Take a look at your meal period waiver practices. So do you have a waiver form? Is it very clear? Does it indicate the right to revoke the waiver at any time? Make sure your managers are also trained on those practices. And then start implementing those reasonable steps in light of the PAGA reform. Take advantage of that, conduct those payroll audits, and make sure your supervisors have a good understanding of wage and hour requirements. All right, so now I want to focus on some employee rights and protection. So I'm going to go over those new regulations on artificial intelligence. That's pretty interesting. And a case law update on reasonable accommodations, and then some new labor law poster and employee notice updates. All right, so starting with the Civil Rights Department's AI regulations, on March 2025, the Civil Rights Department approved regulations that basically address potential discrimination when AI tools are used to make personnel decisions. We've already seen cases that are making this argument. There's the Workday versus Mobley case, where it argues that basically the AI tool was screening out older applicants over 40, which is a protected class. And so they brought a lawsuit for that. We'll have to see how that develops. But basically, the Civil Rights Department here is saying the same thing. You have to be careful that your AI tools are not discriminating against certain groups. This regulation will go into effect in October, and it regulates what's known as an automated decision-making system. So that includes AI like ChatGPT, machine learning, statistics, and other data processing systems. Now, I don't think there's anything earth-shattering about this regulation. I think it kind of clarifies what we can already probably guess or already know. Basically, what it confirms is that our Fair Employment and Housing Act, which governs harassment, discrimination issues, applies to AI. So basically, you're using AI at your own risk. If those AI tools end up discriminating, even if it wasn't your intention to do that, you can be faced with a discrimination or harassment claim. So that's what's known as adverse impact discrimination. It has an adverse impact on a particular group, even though that wasn't necessarily the intent. If you are assessing criminal history and determining whether you're going to hire someone based on their criminal history, you might recall that you have to engage in an individualized assessment where you're looking at certain factors for that individual. They say you cannot use AI alone to do that, to make that assessment. You have to have a human review or component involved. And then if you are using any sort of AI to make personnel decisions, so for example, who to hire, who to promote, you have to retain those records. So at least 4 years from the date of creating them, or from when you took the personnel action, when you decided who to hire, whichever comes later. So make sure that you have good record retention on that. All right, so now I'm going to focus on this new case that dealt with unpaid leave as a reasonable accommodation. So the facts of this case were there was an employee who worked for the Getty. I believe he fell off a ladder and he broke his arm and he needed surgery. And so he first exhausted his family and medical leave, his FMLA or CFRA. But after that, he continued to request continuous unpaid leave as a reasonable accommodation, which we know as HR professionals and business owners that sometimes we do have to accommodate someone, even if they've exhausted all of their protected leave under the ADA or FEHA, we may have to provide them an unpaid leave. But this was one of those situations where it kept going on. So these multiple leave requests extended for about a year, and then they ultimately denied his final request because he requested indefinite leave. So there was no expected really return date. They also reached out and tried to inquire, are there any other accommodations we can provide you in the workplace to get you back on the job? They sent this big questionnaire, and basically the employee said, no, the only thing I need is this indefinite leave. So what the court confirmed here, and this is an unpublished decision, but we can kind of use it as guidance. Again, big surprise, they ruled in favor of the employer. They highlighted that an employer's good faith efforts in the interactive process here supported that it was okay in this situation, these specific facts, to ultimately then end the employment relationship because there's no obligation to grant indefinite leave, and they made their attempts to accommodate this person. They granted repeated requests for this unpaid leave for almost 1 year. They reached out to the employee. They were proactive in exploring other accommodations. So this is a bit of good news for employers. What it does signal is that there could be times where we do truly kind of reach the end of the road. with our accommodation obligations and can end employment. But be very, very careful because it's always fact specific. And unfortunately, there's really no bright line rule regarding how long someone would have to potentially accommodate with an unpaid leave of absence. So it's not like, well, if you do it for a year, then after that, you're okay. That's not what the court said here. They really focused on the employer's good faith efforts. So make sure early on you are engaging with the employee to determine any potential accommodation solutions. And before you end employment, get guidance. It's a good idea to speak with your attorney, especially in these tricky situations where someone has a medical condition or disability and they're requesting an accommodation. All right, now in terms of labor law posters and notice updates, we have some anticipated updates and also an important one that was updated July 1. So first, the EEOC Know Your Rights poster, that's a federal posting. It has been marked as undergoing revision due to the Executive Order 14168. So be on the lookout for that. That's probably going to be changed. As I already mentioned, we have supplemental minimum wage posters. So if you're in healthcare or fast food, make sure you additionally have that supplemental poster up. And then on July 1, the California Civil Rights Department updated their crime victims notice. Now, you might recall earlier this year, crime victims leave was expanded. And one of the things the Civil Rights Department had to do was come out with a new notice for employees. And the law said once the CRD published it, that is going to trigger the employer's obligation to distribute it. And it's very specific. So it says you have to distribute it to all new hires. So make sure to now include this form in your onboarding. Annually to all employees. So if you have not distributed this already, I would distribute it now as soon as possible and then mark your calendars. You're going to have to distribute it on an annual basis. So this is not something that we just hang up and post in our workplace. We actually have to distribute it, which is a little bit unique. And then anytime someone requests this notice or crime victims leave, or anytime they inform you that they or their family member is a crime victim, you do have to provide this notice to them as well. All right, so wrapping up our employee rights, when you are using AI, remember you are using it at your own risk. So make sure that you have some sort of human review or human element just to kind of be another backstop on that. We also recommend implementing an AI policy or for your staff on permitted uses. Maybe you're all for it. Maybe you don't want anything to do with it, or you fall somewhere in the middle. But it's a really good idea to outline that for your employees when they're allowed to use it, confidentiality considerations that they need to make, plagiarism issues, right? All those types of things. We do have a sample policy for CEA members if you do need that. Train your management on leaves of absence, reasonable accommodation rights. And if they don't know the answer on how something should be handled, encourage them to go to HR or the next level of management so you don't misstep there. And then watch out for those updated posters and distribute that Civil Rights Department crime victims notice as soon as possible if you haven't already. All right, so I know we have just about 5 minutes left. I'm going to close out very quickly with some summer reminders for California employers. These are really all refreshers, things that have already been in place, but we're going to cover Cal OSHA's heat illness prevention, annual workplace violence requirements, and then an upcoming Cal Savers deadline for small employers. All right, so last year, California's indoor heat illness standard went into effect. We've already long had an outdoor heat illness standard, but if you are indoor and you have work areas where temperatures could reach or exceed 82 degrees while employees are present, you do need to have an indoor heat illness prevention plan. Cal OSHA does have a template that you can use and customize for your business, but put this on your to-do list if you are not in a fully air-conditioned space. So while the law was aimed at places like manufacturing, warehouses, restaurant kitchens, it's not limited to those industries. We do have fact sheets and resources as well as Cal OSHA on this. But some highlights is when you do reach that 82-degree threshold, you have to provide your employees water. It has to be at no cost. You also have to maintain a cool down area that's less than 82 degrees where employees can go take those cool down breaks as needed. And you also have to have emergency response procedures in place if someone experiences heat illness symptoms, and make sure that new employees or newly assigned employees are acclimating to the heat. In addition to your written plan, you do also have to train your staff on heat illness prevention. And there are some additional requirements that could kick in if you meet what's known as a high heat standard. One example of that is if your workplace reaches 87 degrees. All right, turning to workplace violence. You might have recalled that that went into effect last year. Hopefully you do have your workplace violence prevention plan. There's very limited exceptions for California employers. But what are some reminders? What are some of the ongoing requirements when it comes to our WVPP? So remember, on at least an annual basis, you're supposed to be reviewing and updating your plan as needed. So you want to take another look at it. Did it work for you? Did you have any incidents or concerns, or maybe you do want to increase surveillance, right? Or install locks on office doors. You want to take another look at your plan and update it as appropriate. Part of that process is soliciting employee feedback each year on how they believe you can make the workplace safer. There's specific topics we need to solicit feedback on. We also do have to train our employees annually on our particular plan, and it has to be presented by someone that's knowledgeable in the employer's plan. So make sure that you, after you have solicited employee feedback, reviewed your plan, that you then schedule that annual training with them. You should also be conducting periodic hazard inspections to assess the safety of your workplace. And we also recommend holding safety meetings to get just another way to get feedback from your employees. We do have a comprehensive do-it-yourself workplace violence package if you do need assistance with this. We also do have a PowerPoint template available on CEA Store that has all of the required definitions and topics that you can customize for your business to present that workplace violence training. All right, and finally, CalSavers. So CalSavers Retirement is the retirement savings program for employees in California who are not able to get or enroll in a retirement plan at work. Who it's required for: if you're an employer that does not offer a qualified retirement plan, you must enroll your employees in CalSavers so that they can save towards retirement, but employees can choose to opt out. We've had different requirements to register with CalSavers that have been phased in based on employer size. But now, if you have just one or more employees and you don't have a qualified retirement plan, your deadline to enroll your employees in CalSavers is December 31, 2025. So you have till the end of this year. Or if you're exempt because you do have a qualified retirement plan, like a 401k or something like that, you want to go claim exemption on CalSavers website. So make sure to mark your calendar with that deadline if you are a smaller employer that hasn't done that already. All right, we have reached the end here. So just some final reminders for you. Make sure that you are complying with your annual training requirements like workplace violence prevention. Get that heat illness prevention plan developed if you need it as quickly as possible. We do have safety partners that we work with. So CEA can get you a referral if you need it to Safety Center or Safety Compliance Company to help you develop these plans or conduct the staff trainings. All right, so make sure you're staying up to date on things like your mandatory harassment prevention training, workplace violence, supervisor wage and hour training. Keep that employee handbook current and up to date. Follow those new wage requirements. Make sure you have an updated all-in-one labor law poster on that wall, and then stay tuned to ongoing developments. Again, you can follow our blog at employers.org for your HR updates. And if we did not get to one of your questions today, or if you just want to chat with us, make sure you do take advantage of that complimentary HR hotline provided to you by the Central Valley counties. We'd love to hear from our employers in Central Valley, so give us a call. And if you find you do need some support beyond that HR hotline, again, you can always consider CEA membership. That will give you access to our entire library of HR forms that you can use day to day. Our lowest level starts even on a monthly basis at $125. And then if you need some more support, like with a customized employee handbook or project hours, you might consider Premier or Ultimate. And with that, I will turn it back to you, Anna, to help close us out here.
Awesome. Thank you, Juliana. So I just put, as I mentioned at the top of the hour, the best way for you to suggest topics and, things that you'd like to see in upcoming trainings are by answering that very brief survey. It's only 5 questions. I did just put the link into the chat. And then if you are joining us for continuing education credits, those are on the screen. I will also drop those into the chat very quickly. There we go. So HRCI code today 712538, SHRM code 25-97RRR. Again, ceainfo@employers.org, or just call into your appropriate HR hotline, and we are more than happy to guide you on where to redeem those codes as credit for joining us live today. And yes, and then there is that that QR code, or you can find that link that I just dropped into the chat to suggest trainings and let us know how you liked today's training. Thank you again, Juliana. Thank you, Mary, for supporting us in the Q&A. Thank you, Valerie, and the entire collective behind the Central Valley Regional HR Hotline for all you do for employers in Central Valley. And most of all, thank you all for taking time out of your busy day to join us live and be so interactive and engaged today. We look forward to chatting with you on that HR hotline, and we'll see you on the next training. Thank you all. Cheers.